So I studied English literature and philosophy as an undergraduate, so not law. And then I stayed on to do a master's degree in critical theory. So it was a program run by the University of Sussex. And it was a fantastic course, actually. It was allowed students to take courses across philosophy, literary studies, even film studies, and political theory. And in that degree, I touched on some legal issues, but not really directly. I really enjoyed the program. I learned a huge amount doing it. And I did think at the end, this may not be a natural route to employment. And so I decided to do some law qualifications, which I did after that. And which I really enjoyed, and I was thinking about going to the bar and becoming a barrister. So I did some mini pupilages, spent time in chambers, and did some work experience and so forth, but realised that the bar wasn't going to be for me, and was actually really keen on some of these theoretical ideas that I've been introduced to in my master's degree. And so I started to think about whether there was some way of combining the law and my interest in philosophy and literary studies and critical theory and so forth. And I wrote a very speculative email to someone who's based at the University of London, whose book I'd read. And I sent this email saying, I've read your book, I think it's really interesting. This is where I'm at. I'm having not a midlife crisis, an early life crisis. Didn't really know where I was going to go. And that email conversation ended with him suggesting that I come and do a PhD with him, and that's what I did. So that's how I got so I did that at a law school, doing kind of legal theory, philosophy and law kind of work. And so I kind of got into law in a slightly circuitous route, I suppose. And then having completed my PhD, I then spent 7 years living and working in Hong Kong. So I was based at the University of Hong Kong. That was my first academic position. So that was a really fascinating place to be in and a really fascinating time to be in Hong Kong. It went through a huge transformation whilst I was there. So I learned a huge amount about law, about the kind of questions about politics, political authority, political community that I was interested in and was researching at the time whilst I was there in Hong Kong. So yeah, that gives you a sense of the background, I hope. So I've been here for 4 years, and I've really enjoyed it. It's a great place to be. I'm very excited to be here and love the students, love my colleagues, and very pleased to be in a really exciting research environment. What inspired me to pursue academia? I think one of the things that I was introduced to in my master's degree was this idea that you could read theoretical material, philosophical and academic material, and it gave you a genuinely new way of seeing the world. So the first time I read Marx, for example, or different theoretical approaches, I suddenly saw different aspects of myself, my own personal history, but the world around me in these profoundly different ways. And I just wanted to do more of that. I found that incredibly exciting, that the instinctive understanding you have of the world and social relations and your place in it is only one kind of view, and there are many different perspectives that you can take, and I felt like academic work was one way of exploring these multiple perspectives that you can take on the world. So that's what made me want to go back to studying and spend more time at the library reading and thinking about these ideas, initially at least, yeah. So broadly understood, my work is in legal theory. Legal theory is a broad church. There's a number of different perspectives and approaches. The approach that I have taken in my work is usually described as a law and humanities approach. So That involves looking at legal theoretical questions through the methodologies and modes of analysis that are developed in humanities disciplines. So that would involve looking at literature and literary studies, cultural studies, studies into aesthetics and art and so forth, in order to inform your legal theoretical analysis. So the specific issues that I've focused on in this context has been questions around sovereignty and political community. So we usually associate sovereignty as a concept relevant to states, and it's a key concept within national legal structures, but also international law. And what I've been inquiring into the last few years is around how that concept is being challenged and transformed in the context of the climate and ecological crises. So how is climate change, changes to the environment, changes within the Earth system, challenging how we understand this idea of sovereignty and the nature of political communities within which we live? But I approach those questions with a particular emphasis on questions of representation, symbolism, culture, and draw on a number of different insights from a range of disciplines, really, from literature, literary studies, philosophy, and other areas too. So actually getting interested in the climate issue and ecology and these really pressing issues that we're facing was something that happened quite late on. So I'm not an environmental lawyer, and I hadn't done lots of work in my PhD, for example, on environmental issues. Been more focused on these sort of theoretical questions around sovereignty and political community and so forth. But I started to read some work on these issues around the climate. And I mean, to be honest, initially I was just really scared by it. It was like suddenly really arresting. I think like lots of people who think about the climate crisis, it's there in the background. We know it's one of these big problems that's sort of rumbling along. But I started to read some of the scientific literature on the climate crisis. And I realized that this is a really profound challenge that's going to shape how we organize societies, legal systems, international law for the next, for the foreseeable future. And at the same time, there was this massive absence within lots of the literature that I was reading that really wasn't addressing this issue. It was there as a kind of background concern, like it is for so many of us. So I thought it was really important to engage with this directly. And that's how I became interested in that particular topic, and hopefully drawing on some of these different disciplines that I had training in and some of the other theoretical interests that I had, I was able to approach that topic in a slightly different way to how perhaps other scholars had done so in the past. I think one of the things that you learn at university, and you learn it in other contexts as well, but one of the things that is prioritized in university teaching is that there are a number of different perspectives on any one problem. There's not one solution or one way of thinking about issues that are worth studying in any detail. And so getting students to see that you can approach this problem, a legal problem, a political problem, a moral problem, from a number of different points of view, I think is really important. It's part, essential kind of strategy that I deploy when I'm teaching. So that involves both giving students materials that allow them to assess and compare different perspectives on a single problem, but it also can be born out of conversations among students. So really prioritizing students talking to each other about these issues and understanding where their voice sits in relation to other perspectives, I think is key. Because it's not a question of seeing all these different perspectives and then throwing up your hands and shrugging and in a sort of banal kind of relativism. It's a question of working out how you can situate your view in relation to other reasonable perspectives. So then you can take a considered position that you are confident that you can defend in conversation with others. So trying to get students to that point or that way of thinking is something that I really try and prioritize in my teaching. Yes, so The project I'm doing at the moment is at the very early stages, so we'll see how it develops. But the project that I'm doing is looking at what I call the aesthetic constitution. So when we think about constitutions, we often characterize them as being the meeting place between law and politics. And we would often refer to the constitutions having different legal and political dimensions. So the legal dimension is those rules that are enforceable by the courts that set up state institutions and define the relationship between citizens and the state. And the political constitution, or the political aspect of the constitution, would be all the political processes and political institutions, the debates in parliament, and ultimately, voting and engagement with political parties, etc. So we normally think about constitutions having these two dimensions. So the project that I'm pursuing is to suggest that there's a third dimension there too, which is the aesthetic dimension, which would encompass a range of different things. So constitutions rely on narratives, on myths, on various kinds of fictions. They also rely on different forms of performance, spectacle. This is something I think we're probably quite aware of in the British context. We've still got a monarchy that has all the accoutrements associated with the pomp and circumstance that goes alongside monarchy. And we look at the Parliament. It has not only a kind of dramatic staging within the debates itself, but also all the ceremony and performance that goes around alongside it. But the aesthetic dimensions of the Constitution also speaks, in my view, to the emotions, the way in which the senses in general are organized in order to sustain and reproduce the constituted order. So the project takes this as its starting point, and then we'll look at three different thinkers across 3 centuries, the 18th, 19th and 20th centuries. And these 3 different thinkers, in my view, all turn to this aesthetic dimension in moments of constitutional crisis to try and prop up and sustain and reproduce the constitution and the constituted order in ways that just the law or politics are unable to do. So in moments when the constitution seems to be under threat or it's uncertain in some way, various constitutional thinkers have turned to this aesthetic dimension and relied on devices, techniques, ways of thinking that are proper to aesthetics in order to sustain the constituted order. So the project, we're looking at these 3 different moments, these 3 different thinkers, and trying to understand what this tells us about the history of the British Constitution, for a start, but also more generally the place of aesthetics, symbolism, representation, narrative, and so forth within our constitutional thinking, which is an area that is often sort of acknowledged but usually downplayed. And my instinct is that it's really important, and that constitutions don't function without this dimension working alongside the law and politics. I suppose the opposite of law and context, or the approach that is often contrasted with a law and context approach, would be a doctrinal analysis of the law. So that's looking at legal cases and statutes, understanding their coherence or their lack of coherence, the gaps that they have, etc. Trying to understand whether a series of cases on a particular issue has a kind of logical coherence or not. Trying to think about how the law, whether in statute or case law, may be changed or take a different direction. And so obviously that's really important. That's essential to legal study. We need to read our cases, understand the statutes, and this is an important thing. But I suppose the law and context instinct would say that that doesn't do enough, or there's more to say about the function that law fulfills within society than simply understanding the law on its own terms. So law and context approaches would encompass a number of different contexts in which the law and legal doctrine could be resituated. And that could be in relation to the economy and political economy. It could be in relation to history. It could be in relation to culture. It could be in relation to geopolitics and geopolitical history. So a number of different contexts emerge in which legal questions are situated in order to shed new light on our understanding of the function that law fulfills. So there are a number of contexts in which we can resituate the law. But I suppose what's common to all of these approaches would be that understanding the law simply as a matter of doctrine doesn't tell us enough about the role that law plays within society.